Hello, how are you doing? Welcome to Lawyers Infohub. It's a pleasure to always have you on this platform. I'm Mercy, your host. I'm glad to have you here. For my returning subscribers, I thank you. For those who just watched this video for the first time, you're welcome to this great channel. It's a channel where we talk about law practice with demystified law concepts in most simplified way for ease of understanding. We also share life secrets that will help you prosper, excel in your practice. We talk about tips that will help you as a law student, peradventure a law student watching the channel. The contents will also help you to become a better advocate. So today we are looking at how to manage embarrassing moments in court. As a practitioner, there you'll be faced with certain moments which you can consider as or tag as embarrassing. So we're looking at what are the basic or what are the wisest or what are the good ways in which you can, walk around it and make the embarrassing moment something worthwhile that you will learn, and at the end of the day you will not sulk in the euphoria of how I was embarrassed today or even go back crying. You see, law practice is a profession you need to do with joy because there are challenges. It comes in various forms. So when these challenges comes, what you need to do is to brace up and face it, and take it as this is one of the lessons I have to learn, and you move on. I know something. Some when you learn something out of an experience, it sticks. You can't just get your mind off it, and you just strive to ensure that you don't fall into the same trap or or do those things that made you to face with that embarrassment. So I'm going to give some certain instances. I will talk about ways to go around it. Now, for example, in some offices or in some circumstance, someone might be given a file. For example, you're working for a boss and you're just being handed, just got to work in the morning and you're being told you're going to high court now. You're going to court 10, for example. Take the file. You didn't read the file. You don't know anything about the file. It happens so many times. You see, lawyers coming to court say, my lord, I was just handed over this file this morning. I did not have the privilege of opening the file to know what the content is or what the matter is all about. And my lord, I will seek an adjournment or may I ask for a stand down. You've seen instances like that, and we have seen instances where the judge is like, I don't have time. You mean you even if you were given the file like 10 minutes ago, why couldn't you have opened it? Many judges don't like this excuse because they feel it's a lie. You're lying. There's no way you could have been given a file like this morning to come to court. Like even if the person who gave you the file would have at least explained to you what the matter is coming for. But there are situations where you're just being handed a file and you're rushing to court. You don't know whether you're the defendant, you're claimant or the defendant. You don't even know whether you're the second defendant or you just don't know anything. It happens. And when you find yourself in such situation, what you need to do is, if possible, you ask for a stand down. When the matter, if the other counsel will oblige you, you can just tell my lord, I'm very sorry. I was just handed over this file like 15 minutes ago. I just got into the court and the matter is being called. I may I ask for a stand down, even if it's 5 minutes stand down to understand the position. The position, some judges might oblige you, some others might not oblige. Say, well, counsel, it is just for further proceedings, and if you're lucky, the other counsel might put you through on what happened on the last adjourned date and all of that. But for example, you're for the defendant and you're not for the claimant. You see, the way people will look at you, and maybe the judge will like, who did you say you're for? Or the lawyer appearing for the person you're just called will stand up and say, my lord, no, I'm for the defendant. He is not for the defendant. Such situation look like you're a dullard, you don't know anything, you're so unserious, and many judges may not even be patient enough to what iron it out. So what in such situation, you stay calm and seek for a stand down. But it is also very important that I admonish you that you should not go to court without knowing what the matter is for. Even if for you're on the way with the file, open it and look at the last endorsed uh, proceedings of what happened the last time. Check who are you for, Who are you for? How do you, so, something might like, how do I know? You need to know. Okay, where's the address of your office at the end of the process? Are you for the first? You're a lawyer, by the time you look at the process, you will know whether you're for the claimant or for the defender. Peradventure, the person who gave you the fight didn't explain things to you. But it happens. It happens every time. So don't rush into court without knowing who you are for, not knowing what the matter was for the last adjourned date and what you're going to do. What you're going to do is very critical. It's very important. It's paramount. Because if you never know what you're going to do, then when the court asks you questions, what are you going to say? So situations like this happen. So you have to take it easy. If possible, ask for a stand down, or if possible, identify the lawyer on the other side before the matter is being called. So you can discuss, please, I'm so person from this person, please. I will just hand it over this file. When you got the last adjourned date, what happened? If, for example, if you have there are wonderful colleagues who can say, okay, no problem, this is what happened, we've moved the motion, it's for you to maybe adopt your own counter today and all of that. You can give an idea of what is for. Some other time you've seen people that they doing this to experience, they will get costs will be awarded against them because of they were not prepared, and some costs you cannot appear unprepared. Another circumstance that can lead to an embarrassing moment, for example, is when maybe you are not prepared for a trial and trial is going on. You don't know the right time to object. You allow the opposing counsel ask very questions that is not supposed to ask, and you don't object. I've seen sometimes where the judge will be like, in the presence of the witness, you tell like the defendant, are you sure you're in this matter? And you're keeping quiet? I'm not sure you are prepared. If you can defend. I've seen instances where the judge had to openly tell to the lawyer's face that you can't do this matter. Are you sure you can? You cannot do this matter. The way it's going, you cannot do this matter. And you can imagine the effect of such words on a client. The client will look like, excuse me, you mean the judge could open his mouth to tell my lawyer that he can't do this matter? Then I need to debrief. So these are situations. So if you're not ready to go on, for some people, psychological, you're not prepared, you can ask for a date. Even if it comes on terms, like for cost, you can ask for maybe 5,000, 10,000 naira call. Just, my Lord, I'm not psychologically fit. I'm not strong. There are reasons you can put before the court. Even if the court wants to award, heavy costs, the court will weigh it and say, well, what if this counsel is going on with proceeding and slumps? What will I say? And he mentioned to the court that he was not feeling well. So there's some circumstances the court will weigh it and say, well, this is not bad. Counsel, for the last time you're adjourning, or this adjournment is at your behest, so that you won't come and take a further adjournment. So in such situations, you have to take things easy. You can't just blame yourself. So don't even put yourself in that situation of going to court unprepared for a trial. Another circumstance too sometimes is for maybe a young lawyer, you did not read your file. This happens when you don't read. Some judges will ask, okay, can you just tell me, can you just explain to the court the case of the claimant? What is the case of the claimant? Or what is the case? What is the defense of the defendant? Sometimes it happens for the judge, could be a new judge, or just want to, sometimes it happens. What is the case of the defendant? What are your claims? What is the case? Now, what if you did not read your file? So this has happened so many times. You see people, my Lord, I'm just watching brief. I'm just holding brief for another counsel, or my Lord, I was just giving this file, or someone will come up, my Lord, this, and maybe that is not the right thing. And maybe the client is there moping, looking at like, my lawyer cannot even say what my case is all about. So in such instance, it is good you let the court know, my Lord, maybe this is not my file. I'm just helping a friend, or my Lord, rather than to deceive the court. Sincerely, when you're truthful, the court might, reprimand you, but it's good that you let the court know the truth than trying to say what it's not. Yes. So it's also good for any file you are with. At least look at the claims. And you see, are you for the claim? And look at what are the claims? What is this? At least in 2 sentences, I should be able to say this is a suit of defamation, or this is a issue of is a land case involving ownership, or you can say this is a case involving issue of letters of administration, or this is a case involving just is a contract where there's a default breach of contract. You should be able to, in at least two sentences, state what a case is for. So once you have any file you are going to go to court with, in two sentences, you must be able to state what, no matter how voluminous the file is, to state what what the matter is for at any point in time. So when if you are caught unawares in that moment, you can truthfully tell the court, my lord, I'm sorry, this is not my file, or because if it's your file, at least you should know what the matter is all about. Another thing is when you sometimes an embarrassing moment could also be when you come late to court and maybe your matter has been called and there's nobody you can ask, and you didn't even know that your matter has been called, only for you that you didn't hear your matter. You now raise up your hand, say, my lord, I'm aware my matter was adjourned today, and I've not heard my matter, only for the court to look at what matter is that. You mentioned the matter and they say it has been adjourned. Where were you? Some judges will take it personal, like, why disrupting my proceedings? You came late and you're asking, you wait and ask the registrar. Such can be embarrassing when you're supposed to be in court earlier, you come late, you now disrupt proceedings. Some judges will lash out at you. So what you need to do in such instances to avoid that embarrassment is to wait, or if you can signal the registrar, you know, or ask people what number, or you look at the cost list. You look at the cost, you will not know, okay, what number is my lord? If it's number 4, my matter is number 2. That means it has been called. So don't interrupt the proceedings, or because you want to ask a question you're not even sure of. Such can land you in an embarrassing moment. And peradventure you have not made a mistake of asking the question. What you need to do is to apologize. I'm very sorry, my lord. It was not intentional, my lord. I'm very, very sorry. Don't, you have to be too quick to apologizing. We've talked about court ethics. One of the court ethics you must know or imbibe is the ability to apologize immediately when there is something wrong, or when you have been corrected, or when you have been reprimanded, or when something is not going well and the court draws your attention to say, my lord, I'm very sorry. I thank the Lord for that guidance. I appreciate the court. You must, and you don't just say it in a very sarcastic way, but you say it in a way that shows you're even very sorry. Another instance that can be embarrassing is when maybe a client has debriefed you unknowing to you. You come to court and a new lawyer appears. Or for example, you are for the new lawyer, and you didn't know, and maybe your client did not tell you that there was a former counsel. Some clients can hide some certain things that you begin to wonder what's the problem. Or even if they told you, you didn't do the needful by confirming from the other lawyer, like, I'm the new lawyer now. Please hope your fees, like the RPC indulge us to do, have been paid the ethics of profession. Or you write to the other counsel to say, I'm not the new counsel. Please, can I have the cases or the file or the processes or the document, whatever it is? That is what the law requires that you do. And now you didn't do it, and you come to court and the court is asking you, counsel, okay, and maybe you did not even file a notice of change of counsel, or you filed and you did not even serve the other outgoing counsel. Some judges take it too personal. They'll tell you, you don't know what you're doing. Okay, do you expect me to grant your application when you've not done the needful? There's some things many judges take for you could be petty, but they take it seriously. Another embarrassing moment is when you're talking in court and you don't know that your voice is very loud, and the judge looks at that and says, can you please stand up? Many a times we've seen judges ask lawyers to leave their court or stand up. Can you explain to the court why you're not liable for contempt? You're disrupting my proceedings. Or your phone rings. You apologize, or you handle, don't even argue. Don't deny, because you've seen instances where for over 30 minutes somebody was denied that it was not his phone that rang. Disrupted proceedings, the judge had to rise abruptly and left. That was how the day ended. So what you need to do, if you are caught in the act or you have been identified, just quietly hand over the phone to the security officer, and later you will have an opportunity to want to apologize. If you need to apologize in the presence of the court, apologize, my lord. I'm very sorry, my lord. I rushed in. I didn't know that the phone. I was not even put it in silent mode. I'm very sorry, my lord. This is not in my character, my lord. I respect the court and I respect the Lord. Lord, I cannot be seen. You must apologize and apologize profusely. Yeah, so don't make it look like it was not me, I did not. You start arguing, you are worsening the case. Now, there are courts that have rules. For example, you don't bring in processes in the morning of the matter. You don't call the registrar or signal or pass papers to the registrar while the court is sitting. You don't. That's some, or your phone doesn't ring. I've talked about that. Or you don't wear dangling earrings, or your hair, you don't fly your hair. There are courts that are known for specific rules. Or you don't wear, maybe even if it's a magistrate court, you don't wear off-color suits, or even if it's in the hacker, you're not well properly dressed, your collarette or your collar is not where, some judges are so particular about dressing and appearance. And now you're just there, and the court calls, the judge signals to you and says, can you please leave my court? I can't see you. Or you're not properly dressed, or you're trying to announce appearance, and the court is telling you, I can't see you. And it's rather on you to just bow and step out and see what is the wrong. What some people would do is that a lot, you'll be turning around to see, okay, what is the problem. No, what you do is that you bow and step out and see your hair, you see your necklace, you see your beep, or is it your color, is it your collarette, or whatever it is that was wrong that the court said, I can't see you. So what you need to do at that time, you step out of the court and adjust yourself and come back and apologize. If, for example, you're supposed to not pass papers or processes to the registrar and you're caught doing it, you apologize. It's not a matter of, my lord, it was a you just apologize. And you apologize profusely. These are certain ways that even if the judge is very angry, your approach, the way your reaction sends a signal of respect to the judge. Like, this one is respectful and has understood that he's wrong. Not that you're being cautioned, you're trying to argue with the court and all of that. It doesn't really make sense. Yes, it doesn't really make sense. Another thing, another embarrassing moment sometimes is when, maybe, for example, the court is writing a ruling or saying something and somebody sighs, or somebody makes a very bad remark. People do that. Maybe the court is reading his judgment, and maybe the court reads out his decision and says, "Wow," or you just say things that that can be very, very rude. And most judges, when they point you out or they pick you up or you ask you to stand up, they will wash you. Like, you'll be asking yourself, why did I come to court? So in such instance, you also apologize. Apology is very key in addressing embarrassing moments in court. Yes, it's very, very key. Before I close, another embarrassing moment could be when you did not do a pre-trial with your witness. This one happens a lot. Or you do a pre-trial or conference with your witness who forgets easily. He doesn't remember what to say. He just, the judge will ask you, are you sure you did a pre-trial with your witness? Say, my lord, I did. So in such instance, what you can do is to ask questions that will help the witness remember what he's supposed to say. For example, after tendering, identifying his witness statement of oath, you can say, witness, what do you intend to do with your witness statement of oath? He doesn't remember. Do you intend to adopt it as your oral, do you intend to adopt it as your evidence in this matter? Yes, my lord. You can just leave the witness to say things he's supposed to say, rather than leaving the witness to the obvious or making it so obvious that he does not know what to say. So you can give him an insight as to what he's supposed to say. Because sometimes they're just like, are you sure, counselor, I'm not sure you're prepared for trial. You're in for trial, you've not arranged your document. You're in the presence of the court, you're flipping through. Where is this one? The court will not wait for you. Some judges will lash out at you and even grant costs for wasting the time of the court that they would have they could have given to another person. So when you're appearing before the court, ensure that you've done the needful. Do what you're supposed to do. That if this embarrassment come inadvertently or not what you can buy, if something you cannot control, then either you apologize or you take permission to go out, or you just You take the hint of the court. My lord, I'm very sorry. I'm not known for someone, you let the court know that you're a very respectable and respectful person, that what happened is a mistake. So no matter how angry the judge is, when you apologize, he has a way of melting their heart down. Don't be about someone who feels I can't be corrected. I'm a senior lawyer in this. And sometimes even the way you behave, the court might ask you, counsel, how old are you? When judges ask you, counsel, how old are you? Is it that you're doing something right or you're doing something wrong? I just want to note the age at which you're doing that thing. So you have to be careful when that question is being put at you, your response, and to ask yourself, am I on the right track? Am I doing the right thing? So embarrassing moments as things, some you can't even predict it. I've had situation where I cried. I cried. Yeah, I'm not ashamed to say it. At the early stages of my career, I had I cried, and I told myself this will not happen again. And it wasn't my fault. It wasn't my fault, but I had to just take the blame. But I cried because the judge was not a patient judge. He just left me, and I just rose and not even adjourned my matter. But however, after that day, I have never cried again. But you see, our experiences teaches us a great deal. And having an embarrassing moment doesn't make you less of a lawyer. Rather, it helps you to grow. It helps you to avoid that mistake, or it helps you put you on your toes to be a better lawyer. So when you go through embarrassing moment, don't feel like, wow, what will people think of me? You can recreate that, or you replace or even recreate that impression. So it's part of practice, and get embarrassed as an older lawyer or even as a young lawyer. It doesn't matter your age. What matters is how do you now respond to it or to the situation, or how do you learn after the situation. Friends, it's been a wonderful time. I just hope these few examples will help you. There are also other instances. There are lots and lots of instances, but these are the few I could just pick out and explain what you can do to save the day. We have wonderful comments, videos on this channel. Wonderful, over 200 that will help you become a better lawyer, excel in your practice, become a better student. Learn the acts of advocacy, and be a better counsel, in whatever you're doing or in any area you find yourself as a lawyer. So feel free to go through the channel, look at the contents, send in your comments, send in your questions. We are here to answer it. We believe in the future generation. We believe in the upcoming lawyers. We believe in the younger lawyers. We believe that it takes a lot to grow, and we are doing our little best to ensure that we are contributing our quota to the growth of legal education in Nigeria and Africa. So we are glad that you're here. You're glad you're part of the family. I thank all my returning subscribers and thank my new subscribers too. You've been amazing. You're the reason why we are here, and you're the reason why we'll continue to be here. Thank you for subscribing. Thank you for watching. Thank you for the thumbs up. Thank you for the likes. Thank you for everything. We are really, really very grateful. You want us to talk about other things? You can send a message, send a WhatsApp, send a comment. We'll see what you want us to talk about. Thank you so much, and I really, really appreciate you. Sometimes you feel like you're not getting it right. Keep pushing. Don't give up. When you give up, you don't have a success story. Do take care.